Hello, I'm Emma Tegadine. I'm an employment law partner at Gunnar Cook, and I'm joined today by my colleague, Rebecca Ireland. Hello, Rebecca.
Hi, Emma. I'm really looking forward to our discussion today about living with COVID and the employment law implications.
Yes, and today we're going to be talking about returning to the workplace after COVID and some of the employment law implications around that.
Yes, because you'll remember that it was back on the 21st of February that the UK government announced its Living with COVID strategy, and that included the removal of all legal restrictions. So from the 24th of February, there was no longer a legal requirement to self-isolate if you had a positive test. And from the 1st of April, the government withdrew free universal testing. And then we were told by the government that employees who'd been working at home because of the pandemic were to return to the office. And interestingly, Boris Johnson, back on the 14th of May, he decided to make a renewed call for people to return to the office. And he said staff were more productive, more energetic, and more full of ideas when working in the workplace with colleagues. And he also gave us an insight into his experience of working from home, which was he spent an awful lot of time making another cup of coffee, then getting up, walking very slowly to the fridge, hacking off a small piece of cheese, then walking very slowly back to his laptop, and then forgetting what he was doing on the way. Well, I don't know if that was his way of doing it, but that's what he thought we were all doing. I certainly wasn't. What about you, Emma?
Yeah, I haven't been eating lots of cheese over the pandemic when I've been working at home. It's not my experience. So I'm not convinced that that's the reason why people should be returning to the workplace, because they're spending too long making cups of coffee and eating cheese. But I think there are good reasons why people might need to return to the workplace, or why employers might want them to return. I think in general, people who work at home often find that they can work more effectively because it's quieter and they've got less distractions. And so it can be quite a productive way of getting your work done. Although I did have a client recently express concerns that they weren't sure that the member of staff that they'd employed to work wholly remotely was actually doing any work at all, because they couldn't see what they were doing. They said that the employee said that the camera on their laptop was broken from the first day they had it, and sometimes never switched their work mobile phone on all day. So they did all sound very suspicious, and the clients suspected they may have another job alongside their job. But anyway, I think that's very unusual. That's the only situation like that I've heard about. I think there are more common issues, though, around people working at home that might be more of an issue for employers. So one of the things I've heard a lot is that newer staff and younger staff have been very keen to return to the workplace because they want to learn the job, they want to learn from their colleagues, more experienced colleagues, they want to make friends, they want to socialise. And somebody said to me yesterday that they'd had staff wanting to go back, young staff, because they were living at home and were sort of doing their work sitting on the bed with a laptop on the knee. So, it's easy for us to forget what that might be like, and that not everybody's got an office they can work from. So some certainly younger and newer staff want to return to the office. It's easier for organisations to foster a particular culture if everybody's in the same place at least some of the time. And also, I think perhaps the most important thing to think about is mental health and well-being, and actually being physically with colleagues and regularly seeing people in person tends to have a very positive impact on employees' mental health and well-being. So that's another reason why employers might be keen to get people back into the workplace. And it can be very lonely, I think, sometimes working at home, certainly for a long period of time anyway.
Yeah, and also the businesses themselves feel that they will benefit from people returning to the office, because there's a lot more collaboration that can happen, particularly if you're a creative sector, and innovation when people are getting together and they're actually talking freely. So yeah, definitely. So can employers force staff to return to the office if they've been working at home for the last 2 years?
Well, it depends what was agreed at the time. So some employers will have said to staff, this is only a temporary arrangement that you're working at home. Some employers, and I know of some, decided to make it a permanent arrangement deliberately because they could see the benefits of people working at home. And I think I know a couple of clients have actually downsized their offices accordingly. But then I think there were other employers that didn't say anything. And I've heard of this as well, that they didn't tell staff whether it was permanent or temporary. So nobody knows really what the agreement was. So I think it depends. If it was clear that it was a temporary arrangement, I think it's fairly safe for employers to require people to go back into the workplace on the whole, anyway, subject to what we'll be talking about later. If that's not clear, if it was either a permanent change or it's not clear what was agreed, then I would say that employers probably need to consult with their staff with a view to agreeing with them that they'll change where they work and perhaps go into the office some of the time or all of the time.
Mm. And so what about employees who are unable to return to the office because they've got childcare responsibilities or disability related issues?
So I think this is one of the biggest issues for employers, the issues around possible discrimination. So employers should be very, very alive to issues around people with childcare responsibilities having difficulty coming into the workplace, and people with any kind of impairment, health impairment, which makes it more difficult for them to go into the workplace. Those people, they will potentially have discrimination claims if the employer tries to force them to go back. So in that situation, the employer really needs to try to make allowances for those individuals if it can, to try and reduce the risk of either a disability discrimination claim or a sex discrimination claim.
Yeah, and from the disability side, if you're a carer of someone who had a child who's got disability, then obviously you've got disability by association. So employers need to be mindful of that. Is there anything an employer can do if the employees refuse to agree to a variation to their contracts?
So if employers are unable to reach an agreement with the staff, but they have a good business reason for changing where their staff are working, then they might have to go through a formal consultation process with staff with a view to coming to some sort of resolution. It might even be necessary for an employer to terminate employment and offer re-engagement on the new terms. That's a very drastic thing for any employer to do at any time. So I would certainly never suggest that any employer does that without getting legal advice before they even start the process. So there's something else to think about, and that's collective consultation. So depending on the number of staff that are affected, there may be collective consultation requirements. If they apply, they're very strict. And it's very important that employers adhere to the legal requirements there. So that's another factor to take into account. So employers who are really trying to force this through need to tread very carefully indeed. Definitely get some legal advice. And I would say before they even get there, in terms of terminating and re-engaging, they need to try to reach an agreement with the staff if they can, try and resolve it amicably, and then get advice, I think, before doing anything else.
Yeah, because I think you mentioned that, sometimes there may have been a discussion and that might be clear, but often there hasn't been a discussion because over the 2 years, so much was changing. And so what the employee might think was a permanent change to home working or hybrid working, the employer might be thinking, oh no, it was only temporary. And so if you don't have that initial conversation with the employee as to what you think the situation is and what you now need as a business, you're going to get into difficulties. So yeah, don't assume, employers, that you're on the same page as your employees, and do come to us if you want advice, if you want to regularize the arrangement. So how should employers deal with employees who refuse to return to the office because they're frightened of catching COVID still?
Well, I think that's a really good question. And again, it's something that I think we're both still advising on. And I think this tends to be more of an issue with people who have particular reasons for being worried about returning to the workplace. So the first thing I'd say is it depends on the individual's particular situation and their particular reasons for being worried about returning to the workplace. So the employer should find out, have a meeting with the individual, ideally, or speak to them anyway, to find out what the problem is, what in particular they're concerned about. Are they concerned about COVID in general still? Are they concerned about that particular workplace for some reason? Or do they have health issues which put them at a higher risk than other people? So that's definitely the first thing to do, is to find out what the issue is. If the individual is just anxious, so if they're just anxious about the situation for whatever reason, again, ideally try and come to a solution by talking to the individual and trying to find some sort of workaround. And fingers crossed you'll be able to resolve the issue. Employers should be aware, though, that if the employee has severe anxiety about perhaps traveling on public transport or being in the workplace around other people, it's possible that the anxiety might even amount to a disability and qualify for protection under the Equality Act. So that's something that employers should be alive to. So it may not just be somebody who's worried, it might actually be that person has a disability and has extra rights, and the employer would need to be extra careful in that situation to make sure that they try to accommodate that person if they can. So I think, as I say, the first thing to do is to find out what that person's particular issue is, and, as I say, consider the possibility that there may even be a person with a disability if they've got severe anxiety about it.
Yeah, and you were saying that the disabled have protection. What about employees who aren't disabled? Do they have any extra protection?
So all employees who've been employed for 2 years or more have the right not to be unfairly dismissed. So if a person's been employed for 2 years, they have those rights, and that means that if the employer is, if they're at loggerheads, if the employer and the employer are at loggerheads and they can't reach an agreement, and the employer is thinking about terminating the person's employment because they won't come back to the office, well, you've got a potential unfair dismissal claim there. So the employer would need to, again, be careful about how it goes about terminating the person's employment in that situation. Go through a fair process, consult with the individual, make sure it's reasonable to dismiss in the circumstances, make sure it can't accommodate them in some other way. So just be careful, because there's a risk of an unfair dismissal claim. Also, even if a person is not disabled, and even if they've not been employed for 2 years, they still potentially benefit from protection in relation to issues around health and safety. It depends on the situation. But an employee who is dismissed because they refuse to come to work will be automatically unfairly dismissed if they leave or refuse to return to work in circumstances where they reasonably believe they are in serious and imminent danger. So if an employee can show that that's the reason why they were dismissed, then they'll be able to claim unfair dismissal even if they haven't been employed for 2 years. And workers are similar to employees, but they don't quite have quite as many rights as employees. Workers have similar protection as well in relation to detrimental treatment. There is a potential still for a health and safety related unfair dismissal claim, even if someone's been there less than 2 years and even if they're not disabled.
Yeah, I mean, I picked up that there'd been a 3-fold increase in tribunal claims citing health and safety concerns, and there's likely to be a significant increase in claims for employees who were dismissed for refusing to work on COVID-related grounds. Have there been any reported cases yet?
In relation to health and safety?
Yeah, because obviously we've seen an increase in the number of cases being brought, but I'm just wondering whether, I think I recall seeing an EAT case.
So in terms of employment tribunal claims in general, there's a massive backlog in terms of claims getting through the system. So in some parts of the country, it's taken 2 years for cases to be listed for a hearing. So it's not surprising that there haven't been many cases coming through yet, because they'll still be in the system, probably a lot of them. But there has been one very recent case, which is a very interesting case, and that's Rogers and Leeds laser cutting, which, as you say, is an employment appeal tribunal decision, and that's just in May this year. So in that case, the EAT upheld a tribunal decision that an employee who worked as a laser operator had not been automatically unfairly dismissed for leaving the workplace and refusing to go back, when he claimed he was worried about catching COVID and passing it to his children. He was dismissed and claimed that he'd been automatically unfairly dismissed because of the reasons I said before, because he refused to return to work in circumstances where he said he reasonably believed he was in serious and imminent danger. So that's what the case was all about. So the tribunal found that the claimant had not established a reasonable belief in a serious and imminent danger in relation to COVID, because, amongst other things, he hadn't taken any steps to avert the danger. He hadn't raised any concerns with the managers before he left work, and the employer had implemented all the government guidance on hand washing and social distancing and all the guidance that was in place at the time. So in that case, the evidence didn't demonstrate that the claimant's decision to stay away was directly linked to concerns about the workplace. Rather, I think the real issue was that he was concerned about COVID in general, and the fact that one of his children suffered from a particular disorder, particular illness, which made them particularly vulnerable. So I think a lot of employers breathed a sigh of relief when they heard about that case.
Yeah, I mean, does that mean that health and safety related claims based on COVID are unlikely to succeed? You know, because the employer did as much as they could, and it wasn't an serious imminent danger.
Well, not necessarily. I think it depends on the facts of the case. And as I said before, we haven't. That's the only case that we've had come through the system yet that's gone to the EAT. And it's definitely conceivable that an individual will be able to bring a successful claim in circumstances where there is a workplace where there's a higher risk of contracting COVID, where that employer has not taken appropriate steps to mitigate the risk. So it depends on the nature of the work, the nature of the workplace, and what steps the employer has taken to reduce the risk, and also whether the employee genuinely has a reasonable belief in a serious and imminent danger. The employee's own health might be relevant. So an employee with a suppressed immune system may be put in serious and imminent danger in circumstances where an employee without that kind of health condition will not. But I would say that it's likely to be hard for an employee to establish what they need to establish if the employer has followed the government guidance in relation to what they should be doing about COVID and minimising the risk. And also if the employee hasn't raised any particular concerns during employment with the employer.
Yeah, and actually it's the guidance that was in place at the time. And you know, you and I, we've lived through the last 2 years, and that guidance was changing all the time. And the problem is that it's keeping abreast of what you did at a particular time. And I read an article recently about obviously making sure you keep your records, because there may be claims that come out of the woodwork later. Yeah,
absolutely. I totally agree with you, and I think the fact the guidance changes, almost weekly sometimes, does make it quite tricky sometimes for employers. I know that I had we've not really talked about this yet, but I had an issue with a client where there was an issue around vaccination, and my advice was, you need to follow the government guidance. The guidance says this, and this is what you can do, and this is why. And so we went through a whole process with this particular employee, and while we were halfway through the process, the guidance changed. so
it was a difficult time. Yeah. So we're just talking about, the government public health guidance, and it has changed frequently over the last 2 years. And employers have had to keep on their toes and regularly update their health and safety practices so as to comply. So remind me, what's the current guidance?
So, as as I was saying, guidance seems to change all the time. But the latest guidance is, I believe, the working safely guidance, which talks about reducing the spread of respiratory infections, including COVID-19 in the workplace. And the emphasis is quite different. I think it's a lot more minimalistic in terms of what employers are expected to do. So, so we certainly recommend employers and people advising employers to go away and have a look at the latest guidance if they haven't already done so. But in brief, some of the key points are employers are expected to maintain clean working environments, encourage people to be vaccinated, and consider improving ventilation in order to reduce the spread of infection. Also, the requirement for employers to explicitly cover COVID-19 in the health and safety risk assessments, that's gone. Employers need to continue in relation to the usual legal requirements in relation to cleaning, ventilation and welfare facilities. And employers should consider the particular needs of any employees who are at greater risk from COVID, including people whose immune systems mean they are at higher risk than other people.
Yeah, and I do remember that shielding for clinically extremely vulnerable individuals in England did end last September. But as you say, the government guidance still states that those people who were previously considered clinically extremely vulnerable, although they're considered to be well protected now because they've had their primary and booster vaccinations, you've still got to, as you say, check that there isn't something specific that that they're concerned about. And if they've got a weaker immune system, then clearly they are still at a higher risk of serious illness. So I think although the guidance is saying, don't worry, light touch now, keep considering the needs of those employees who are at greater risk, and just be really careful. Is there any specific guidance for those who do have a weaker immune system?
Yes, I think that the government still has particular concerns about certain individuals, people with certain conditions, including people with weakened immune systems. And there is specific guidance for people with weakened immune systems called Guidance for People Whose Immune Systems Mean They Are at High Risk. And
title there.
And it recommends, amongst other things, that those kind of people should continue to wear face coverings in public places, work from home if possible. So that's very relevant to what we're talking about today, and speak to their employer about what arrangements can be made to help them reduce the risk. Also, so they should reduce the amount of time they spend in enclosed spaces, again, very relevant in terms of returning to the workplace, and practice social distancing if possible. So there are a lot of things there which mean that for those kind of people, actually working in an office environment or an enclosed workspace might not necessarily be appropriate.
And is there any guidance for employers about how to deal with employees who are still particularly vulnerable? So, outside of this immune system guidance?
So there is some good ACAS guidance. So there's some ACAS guidance called Going to the Workplace During Coronavirus, People at High Risk from COVID-19. And that states that where people are at high risk and have not returned to the workplace, and either they want to go back or their employer wants them to go back, they should discuss the following things with their employer. If and when they will return, flexible working arrangements, including home working and hybrid working, what the employer has done to make the workplace safe, any concerns the employee may have about returning to the workplace, and any reasonable adjustments the employee might need if they have a disability. The ACAS guidance states that a doctor might advise somebody who is at high risk to stay at home, and that in those circumstances, the employer should consider whether they can allow the employee to continue working at home. So where a disabled or a potentially disabled employee refuses to attend work because of increased risk, the increased risk to them associated with COVID, I would suggest that the employer seeks some medical advice as soon as possible, either from the individual's own GP or from an occupational health specialist, to clarify what those risks are and see what adjustments might be made to assist that employee.
Yeah, yes, it is important to look at adjustments, because employers who fail to make reasonable adjustments for clinically vulnerable workers by allowing them to continue working from home or failing to provide a safe working environment for them, they do run the risk of a claim for discrimination being brought against them, or breaching the implied term of mutual trust and confidence, or just general health and safety, legislation. There's a lot out there. So yeah, really do talk to the doctors, talk to the occupational health, and see what you can do to accommodate the needs of your disabled employees.
Yeah, I think it's really hard to know how this is going to be resolved, this issue about return to the workplace. And my view is, I don't think there's one size fits all. I don't think employers can just do one thing for everybody, because I don't think it's going to suit everybody, and it's not what everybody wants. And also, as you rightly say, moreover, there's an issue around discrimination anyway. So, regardless of anything else, you've got potential discrimination issues, potential health and safety related claims. So I think employers probably need to be a little bit flexible in terms of what they require of their employees and who they require to go back into the workplace.
And it's difficult for employers because they can't necessarily explain to the rest of the workforce why they're treating someone else differently. And what I've seen is a certain amount of, not hostility, that maybe that's a little bit too strong, but even when last June, when people were trying to come back on a hybrid working and different teams coming in, there ended up being so many exceptions, because there were trying to be a rule, but then there were so many exceptions, and that did create a little bit of tension in the workforce. So it's not an easy task for the employers, and I bet we'll see, as we go into autumn, that maybe this living with COVID strategy will have to change again, depending on how the virus has mutated, I suppose, at that point.
Yeah, and I mean, it's not quite on what we're talking about, but a related issue I've been advising on this week is, it kind of touches on what you just said about people resentment from other employees. So I was advising a client this week about an issue where somebody's been off for a very long time with a very serious illness, and there's no doubt that they've been very seriously ill. They've been treated, and they've finally returned to work, and the employers put certain adjustments in place for them, and other members of staff are unhappy about that, because they're disgruntled, because they think that they're taking advantage of their situation. So yeah, I think the same thing could apply here. People won't necessarily know why employers are being more flexible with certain individuals, and even if they do know, they might think the individuals are just taking advantage of the fact that they've got a particular condition or children or whatever it might be. So yeah, I think that's quite a tricky thing for employers to navigate.
It is, definitely. So Emma, the requirement to self-isolate after testing positive for COVID, that was withdrawn in February. But what does this mean for employers when an employee has been exposed to COVID or has symptoms which are consistent with COVID?
Well, it's quite tricky at the moment, I think. It's quite tricky for employers and employees. So the deemed incapacity provisions, which were introduced back in March 2020, meant that for quite a long time, individuals who were self-isolating because they tested positive for COVID were eligible for statutory sick pay, which worked well for everybody, really. However, those provisions ceased to apply on the 25th of March 2022. And that means in order to be eligible for SSP, an individual must actually be sick. So as we know, not everybody who has COVID is ill. Some people who have COVID and they don't have any symptoms. So people with COVID who are asymptomatic or only have very mild symptoms are no longer eligible for statutory sick pay. So in terms of where we are now, we've got the removal of universal free testing. So I think the majority of people aren't testing themselves anymore at all, because it costs money, about £2 a test. So then
unless you've got your stockpile, Emma.
I don't have one, unfortunately. But anyway, so yes, or unless you've got a stockpile. So removal of universal testing, so that's gone. So which means a lot of people can't or won't test, especially because nobody's got any money either because of the cost of living crisis. So people aren't testing themselves hardly at all. People who have COVID only get statutory sick pay if they're actually ill. So even if you do test positive, if you're not ill or not ill enough, you don't get statutory sick pay. And then there's no requirement anymore to self-isolate with COVID, whether you've got symptoms or not. So all of those things, I think, lead to a situation where you've got the potential for a COVID outbreak at work. You know, you're not necessarily going to know whether people have got COVID, and even if you do know they've got COVID, they might still come into work.
Yeah, I mean, but can an employer stop an employee coming into work if they've had a positive test, or if they've, they're suspected of having COVID symptoms? Can they actually say, no, don't come in?
Well, that's a good question. So employees don't usually have a legal right to go into work as long as they get paid. Okay, so the vast majority of employees, they've got the right to be paid, but no right to actually go into the workplace. So if an employee has COVID, or for whatever reason an employer is concerned that that individual might be infected with COVID because they've been exposed to it, or because they seem to be displaying symptoms, then that employer may decide to ask that individual to stay at home until they've recovered or the risk has passed. So employers should consider in that kind of situation whether the employee can work at home. Can they carry on working but do it from home if they're not too sick for a period of time? Or they might even consider providing testing kits for individuals so they can see, well, hopefully see whether or not they actually do have the virus. That's something else that might help.
Yeah. And what about an employer? Do they have to pay an employee if they're sent home and can't work remotely? So they've decided, we don't want you on site because we're a bit worried you're going to spread COVID, but we also you can't do your job at home. I mean, where does that leave the poor employee?
So employees who have COVID and have COVID symptoms, they're entitled to statutory sick pay, or if they've got any right to it, to contractual sick pay in the usual way. Asymptomatic employees with COVID who are ready, willing and able to work are entitled to be paid. So if they're willing to attend work and are told not to, then they will be entitled to their normal wages.
Is there any legal requirement in the UK for employees to be vaccinated against COVID?
No, there isn't. There's no legal requirement at all, although obviously the government is strongly encouraging everybody to get vaccinated as long as they're not a person who's told not to do on medical advice. So the government had passed legislation requiring frontline health and social care workers and people working in registered care homes to be vaccinated. However, those provisions did prove to be quite controversial, and the requirements were revoked in March 2022.
Yeah, and actually I had some clients who had to implement the regulations when they were actually in force. And one of the questions that came up was, what happens if someone turns around and says, well, you had to dismiss us because I didn't want to have the vaccination. Can we come back? And no, you don't have to take them back, because at the time the employer was acting on the regulations at the time, and there was a statutory restriction, and so it was fair for them to dismiss because there was a statute telling them they had to, and despite best efforts to try and relocate them elsewhere, there wasn't another role for them. So it has affected people. This, I suppose you could call it a U-turn. But can employers, so now we haven't got any legislation, can employers actually require employees to be vaccinated?
Well, I think that's a really pertinent question, and it's a question that I have been asked by quite a lot of clients, during the course of the pandemic, during the latter parts of it when vaccination has been available. So many large employers, including Amazon and Asda, have made a public commitment to encourage their staff to get vaccinated. However, a blanket mandatory vaccination policy, which is applied inflexibly, is likely in a lot of cases to be unlawful. So an employer that's thinking about introducing its own mandatory vaccination requirement for its own staff should consider the following things. Vaccination is not recommended for everybody. So there are certain individuals who should not be vaccinated because of their own particular situation or medical circumstances. Depending on the particular situation, a requirement to be vaccinated may not be a lawful and reasonable instruction. So that's the issue, really. Is it a lawful and reasonable instruction to require all your staff to get vaccinated? And if it's not lawful and reasonable, that could lead to potentially constructive unfair dismissal claims. There's an issue in relation to potential indirect discrimination against employees and workers with certain protected characteristics, such as religious or philosophical belief, disability, or age. So there are issues in terms of discrimination. And employers should also be aware that there are likely to be data protection implications in relation to requiring employees and potentially workers to provide information about their vaccination status. So I'm not saying that you can never do it. I'm not saying that employers can never do it. But I think it does depend very much on the nature of that particular organisation, what kind of work is being done, and why the employer has decided to introduce that policy. Tribunals are unlikely to consider a mandatory vaccination requirement to be reasonable unless it is essential for the employee to carry out their particular role. And there's a very good explanation for why the employer is requiring it. So whether a vaccination requirement is a reasonable management instruction will depend on the facts of the case, as I say, including the nature of the role, and also potentially the number of vulnerable individuals working in that workplace. That could be a relevant factor. And the latest government guidance will always be a relevant consideration.
Yeah, we saw that earlier. Yeah, keep up to date with the guidance is what we would say to our employer clients.
Yeah, well, I think I've certainly been saying all the way through the pandemic, with everything, furlough, vaccination, COVID, workplace issues, health and safety. I just keep saying, just look at the guidance, follow the guidance, go to the government guidance, because I think, to be fair, going forward, if there are claims, it's something concrete that employers can point to in terms of, well, this is why we did it. This is what the guidance said at the time.
Exactly. Well, it's been absolutely fascinating talking to you, Emma, and spending the afternoon talking about living with COVID. And yeah, see you soon.
Yes, thank you very much. Bye, Rebecca.
Okay, bye.